Litigation is often complex and multifaceted. Not surprisingly, it is an area where we continue to see a high number of professional negligence claims against solicitors. In this program, Janice Purvis, Solicitor and Manager of Practice Support Services at LawCover, and Melissa Fenton, Partner at Colin Biggers and Paisley, discuss recent cases which highlight the key risk areas in litigation practice. We examine how each matter can present a different set of risks, how you can recognise this risk and manage it effectively.
Welcome to Risk on Air, Mel.
Thank you very much, Janet.
And you certainly are an expert on the litigation issues. The reason we're talking about litigation today is, of course, unfortunately, there seems to be an increase in professional indemnity claims in the litigation area.
Yes, that's right. It's a bit of a minefield, I think, in litigation because it is an area of high pressure work environment for lawyers. The clients have high expectations, there's court pressures, and things can happen in a very fast pace. So there are lots of areas where mistakes
where things can
happen.
go wrong.
Yeah,
absolutely.
Exactly.
Because there's lots of aspects. There's lots, I call it a bitty type of work in the fact that not only are you doing bits and pieces at different times along the spectrum of the litigation, but you've got different people doing things. You've got junior lawyers doing it, sometimes the partners doing it, different people talking to your clients.
Yes.
You're going to court.
Yes.
You're providing advice. So
That's
there's
right.
lots of places where
there
things...
are so many places where things can go wrong, and I think the pace these days of litigation is very different to what it was 5, 10, 20 years ago. Even now we have online court.
Oh,
which
that's interesting.
Means, so orders have to be made. Entry by 2:00 and the other side have to reply by 6:00 that same day. There's a lot of pressure on solicitors to be on top of everything. And like you said, when you've got clients and court and then internal procedures within your firm, you can see how things can go wrong.
Absolutely. And of course, I didn't realise, of course, the technology aspect, as you said. I mean, now lots of courts are online. In fact, they're even... especially in criminal matters, a lot of the matters are videotaped. You've got your client actually sitting in a cell back at the prison. That type of thing.
It is. I guess law, it is slow to evolve, but it does evolve. There are some really good cases that have been delivered in the last year or so in the Victorian courts and here in New South Wales, where they have looked at where lawyers have fallen short, if you like, in the negligent management of litigation. There's lots of traps, things like failing to comply with court orders or settlements where perhaps you've thought you've done the best you can for your client, but at the end of the day your client's unhappy and they turn around and then say, well, I wasn't given the correct advice. So that is a real... Is that an area where you find...
Absolutely, and I think probably the settlement area is maybe a good place to start, really. When you think about in any litigation at any time, you're always discussing some form of settlement with respect to your client, but in particular when you're having specific settlement conferences. And to name a case, of course, probably the most pertinent one from 2018 is the Spralger and Bullard case. I think that's how you pronounce it.
That's right.
My apologies to Mr. Spralger if I've got the pronunciation wrong, but it's the Spralger case. And my understanding is Mr. Spralger was in litigation with a Mr. Kelly in relation to the sale of a fishing permit and shark catch quota. The litigation was settled. However, afterwards, Mr. Spralger asserted that his solicitors and barristers did not really advise him properly with respect to the settlement terms.
That's right.
In fact, he even went as far as to say they forced him into the settlement terms and that he did not agree with them. And as any litigator will appreciate, that after a settlement, after your client has gone home and thought about it, some of them are happy in hindsight and many are unhappy in hindsight.
And that's not uncommon. I mean, that's the spirit of compromise. A lot of mediators will say to you, everybody's going to leave today not feeling like they've been satisfied. So that's the whole spirit of compromise. But that is the challenge. And I know in Mr. Sprowger's case, there were a couple of factors that were influencing why he felt that he didn't get the settlement he achieved. I mean, he made accusations against the lawyers that they should have realised he wasn't feeling well at the time that he was talking about settling the case. He also said that he didn't really understand the way that they had explained the settlement to him. A lot of the criticism that Judge Woodward had in this case was that the lawyers, when they were explaining to him the pros and cons of proceeding with the litigation, they focused on the negative aspects, which I think is a bit of a common theme for many lawyers. Litigation is expensive. The cost consequences of not succeeding can be very significant. And so there might be a tendency to focus on the negatives rather than the positives. And I know Mr. Sprowger's complaint in this case was the solicitors didn't tell him or didn't give him enough information about the good parts of his case.
Yeah, but I understand it that they concentrated on the risks of losing the case and all the holes in his case. But as the judge said, he said they didn't advise him at all on, well, he did have prospects of success.
Yes.
And the good points of the case, and that these would issue.
That's right. And in fact, Judge Woodward said the advice that the lawyers had given to him was actually superficial and quite unbalanced. And he actually thought in part misconceived. And he thought that there was actually definitely much better prospects of Mr. Sprowger succeeding, and his lawyers, it was incumbent upon them to explain that to him. So I mean, I feel for lawyers in that high pressure environment, because it is difficult to explain the risks to your client. And as a lawyer, it's something that you do every day, but for your client, they're not probably involved in litigation every day. So it is difficult to ensure that they understand the risks.
And it is incumbent upon you to ascertain as to the mood, health or whatever of your client as well, as to if they are really understanding it. It's not good enough just to provide the explanation. It's actually incumbent upon you to ensure your client understands it.
You know, Janice, that's a great point, because I was going to say, we as lawyers, we advise on the law and the prospects, but we also have to take into account we know our client. It's our job to understand our client.
Absolutely.
And what their needs are and what the outcome means to them. And it won't be the same for every client, even though the law that applies is the same. That's excellent.
And certainly I've noticed in a lot of the very complex cases where there are complex damages, and again, I think Justice Woodward alluded to this, is you should do a lot of work beforehand. They should have had a table showing the minimum and maximum likely awards for each of the heads of damages, and that they hadn't explained to Mr. Sprowger accurately enough as to the cost, the damages and cost issues as well.
That's right, and the strengths of the weaknesses, the suitable settlement range. We all know it's not just one figure. There'll be a low range and a high range. Yes, Woodward did.
And of course, the magic thing that we're always talking about is you should take lots of contemporaneous file notes as to what you've actually said, and even have the client sign the settlement document, the settlement instructions, even before you get to the binding documents, whether it's heads of agreement or an actual deed, that you should actually have your client sign the settlement instructions so that they're clear as to what they are telling you.
That's also an interesting point, because in this case he did sign, and he said that he felt that he was pressured to sign because the news that he was hearing from his lawyers was that it was all doom and gloom, and he felt that there were some very significant cost consequences if he didn't accept that settlement. It was a really, really good observation in this case as well that Woodward, and I think I mentioned this to you earlier when we were talking, that if you don't have documents like file notes or even ideally signed documents with the client's instructions, the court does tend to prefer the evidence of the client in these scenarios. And that's because they don't go to court every day like lawyers. And so their memory of the events is likely to be far clearer than a lawyer who might have 20 clients or 20 matters going to court in any 1 week. And I thought that was an interesting point that he raised.
Absolutely. And that is not only in respect to litigation claims, it's in respect to any claim in any area of law. The fact that the documentary evidence will certainly be preferred over anybody's memory and good contemporaneous file notes. And I can totally recognise, being a lawyer myself, that sometimes you think, oh, God, I can't be bothered, or you're racing off to the next meeting or client calls. I'll get around to that file note. I'll get around to documenting it. And you just don't get to in the end.
Well, and often you might be in hearing 10 years later. So the chances of you actually then recalling what happened then. There is one case, and the name escapes me at the moment, where evidence of the solicitor's usual practice was accepted instead of a specific file note. But that particular solicitor had a very structured, orderly way of working. So
it often does not get you over the line.
No.
And use technology these days. It's a lot easier. I, for instance, often used to pick up a dictaphone. Now you can have drag and dictate on your
use that.
computer
I do it straight away, yes.
so that it makes it a lot easier than having to actually type it out or longhand. But even typing is certainly a lot quicker than writing it out longhand. So you have the opportunities to make file notes, even if you're using a dictaphone and you're getting your secretary or assistant to type it out for you.
Another good way of using technology is emails. I'll get off the phone after I've spoken to a client, and then I'll send an email confirming our discussion, and then that becomes the file note on the file.
Absolutely. So that's a fabulous way, because it's cementing the communication that you've had. An excellent way. And probably before we leave the settlement area is, in the last year or two, there's been a very significant, or two very significant matters that came out of the High Court of interest to solicitors. And I see you've got a quote there.
These are close to my heart, because I've followed the advocates' immunity
and that's what we're talking about,
development
advocates
for
immunity.
a long time. Most lawyers would know about the advocates' immunity, and you're right, Janice, in the last year or so there have been two very significant High Court decisions in both Atwells and Jackson Lalich and Kendrigan and Lepore, and both of those decisions have fairly much established the law in Australia now, which is that the scope of immunity for advocates has been clawed back from what it has been historically, and it's clear now that it doesn't extend to giving advice about settlement. So historically we might have been able to say that advising clients on settlement ranges and giving them options was part of litigation, and therefore if they were then unhappy, we would be protected by advocates' immunity. Well, it's now very clear that is not the case in Australia. It is not considered closely connected to the work that's conducted in court, and you won't be protected. So all of the things that we just talked about in terms of protecting yourself when you are giving settlement advice is, make sure that your client has had sufficient time to consider what your advice is, so that they're not making any decisions on the fly and feeling pressured. That you've also given them considered advice, both pros and cons and ranges. And ultimately, it's their decision. You're there to give the advice, but it's their decision. So
absolutely. And it can be difficult when a lot of these settlement discussions are actually done when the hearing is progressing. And that can be very much on the fly. And then it's even more important that you provide the notes and the really considered advice, because, it is not covered by advocates' immunity.
That's right. And in my experience, it's sad but true, there is still a lot of negotiation on the doorstep of the court, particularly in the regional sittings when you've got rolling lists. It's a really common occurrence. So,
okay. Well, we might lead on to another subject now, and I thought this was a really interesting case of Rami and Saturis. This was some litigation which was involving a gentleman and his companies, and the gentleman and / husband and the companies were impecunious, put it that way, and did not have any funds to pay for the litigation. The wife, however, appeared to be have significant
the
financial
asset holder, that's right.
significant financial advantage.
Yeah.
So the lawyers did a deal, I suppose, with the wife, and the wife agreed to pay for the litigation.
Which is not unusual. I mean, in
Not
that
unusual
scenario.
in a husband and wife scenario. However, the litigation was in respect of the husband only and the husband's company. The wife
right.
was not a party to the litigation.
Correct.
But there was this unusual aspect of it. It wasn't a funder coming in as a third
I was going
party.
to say it's almost like a litigation funder, but it's not. She's almost underwriting her husband's prospects by agreeing to pay his legal fees.
Absolutely. In this particular matter, it's a good example. This was a law cover case. The insured solicitor was acting in the litigation involving Mr. Rame and his companies, and as I said, had no real assets. The assets were in the name, Mrs. Rame's name, so she was asked to enter into an agreement to pay the costs of the litigation and to grant a charge over property to secure the liability under the costs agreement. So the wife was actually entering into the costs agreement, not the client.
That's right. And offering a mortgage.
Absolutely. The undertaking of the work, it was made it clear that Mrs. Rame was not hurt the client, and it also said she needed to seek independent legal advice in relation to the costs agreement and the charge.
And that I wanted to say at that point that is excellent advice from the lawyers. Very, very careful. I've certainly, in my experience, seen a number of lawyers seek mortgages over clients' properties to underwrite, if you like, or secure a costs agreement. And it's very important in that scenario to make sure that they've had their own independent legal advice. And even more so here when she had no personal interest in the litigation.
Absolutely. And of course, you've probably all guessed, the litigation at the end of the day went pear-shaped.
It wouldn't be a story otherwise.
Well, no, it wouldn't be on a radar, would it? It went pear-shaped. The wife decided to sue the solicitor. She said the insured breached his fiduciary obligations to her in entering into the costs agreement and taking security of the property, and that he gave negligent advice as to the prospects of the success of the litigation. Now, this is another aspect altogether. Justice Emmett said he was satisfied that the solicitor was not acting for the wife at the relevant time, and that they did what they should have done in that they referred Mrs. Rame for independent advice in respect of the costs agreement and the security documents.
They did.
However, there was a catch in it. There was no advice given in respect of the prospects
that's
of
right.
the husband's case that she was underwriting.
Yes. But I think that also Emmett was critical of her in not asking for that advice as well.
I think they had also said to her, the lawyer she went to see in respect of the costs agreement and the security, the lawyer actually said to her, you should get some advice in respect of the success of the litigation.
Yes.
I can't give that to you because I'm not involved in the litigation, but you should go back to your husband's solicitors and ask their advice in respect of it, or indeed hire somebody else who was in a position to be able to give you
that
informed advice.
Exactly.
And she did not do that.
Yeah, and I think the costs here that she was exposed to were in the order of around $250,000. So it was a significant loss to her to not do that. But she did sign it knowingly, and when she signed the cost agreement, she also signed an acknowledgement that she had obtained legal advice about the document. And I think that was why Emmett was quite happy to find that the lawyers in this case, the insured lawyers, had done all that was reasonable in the circumstances. So the solicitor had made it clear multiple times that she needed to go and get independent legal advice.
We must note that apparently this particular case is under appeal. So we'll certainly be watching that.
Yes.
But certainly Justice Stevenson said that the wife herself did not do herself any favours and she should have taken reasonable steps, especially in respect that she got that advice and she didn't
I think
do
this
it.
case is also a good reminder, and the lawyers here, the law cover insureds, did a very good job in differentiating between their client and the third-party payer, because that
Absolutely.
can be blurred sometimes. And I think where it is blurred, you mightn't get such a strong decision in your favour and you may actually be exposed. So that's another good takeaway.
And as we know, in litigation, sometimes obtaining your costs can be a tricky issue. So
Yes.
So-
And as we said earlier, litigation is expensive, so people will do what they can to avoid, which is probably what Mrs. Rame was
Absolutely.
attempting to do.
Now, when we introduced this topic and we were saying that litigation, there were lots of aspects to the litigation, lots of bits, different people doing different aspects. I think this is highlighted in this particular case.
Oh, this case makes me so sad. It's terrible.
It is a train wreck.
It is a train wreck, and I do use this in my risk briefings actually because it is so horrific.
Absolutely. And the case we are talking about, we should tell our audience exactly
Yes.
what we're talking about. This is the Berry Rural Cooperative Society Limited versus CPAC Industries. And it's a 2018 claim. And just to remind you, you'll be able to get all the citations for these cases on the email which delivers the Risk on Air podcast to you. Do you want to...
Yes. Look, this is a very sobering. I have circulated this decision to all of the solicitors that I work with because it is... I think you said earlier too, you know, in a firm you may have juniors working on files and then you might have your partner and there are solicitors on the record. And this is one of those cases where you can see how competent judges will not tolerate default and they require accountability. So in this case...
And it's in the commercial list in the Supreme Court. You know,
Yes.
we're not in the local court in a rural area. This is the Supreme Court commercial list.
This is Hammerschlag's list, which
Yes.
is a renowned list for a svelte operation. But this case, the plaintiff solicitors who brought the case on behalf of the Berry Rural Co-op, they had sold some equipment to the defendant and the sale went wrong, and so they ended up in litigation. And in the course of then bringing the proceedings, the solicitor for the plaintiff consistently failed to meet court orders. So, you know, we all know in litigation, once proceedings are filed, you'll get a court timetable, and that'll list a progression of what needs to happen with the view to having the case concluded in 12 to 18 months. So plaintiff didn't comply with any of these orders. Finally, the judge lost patience and Hammerschlag ordered what's called a guillotine order. So litigators amongst us will know what that means. It's like you've got one chance. If you miss this final chance, you are prevented from serving any evidence. And that can be fatal to a case. If you're going to trial and you've got no evidence, then you've definitely got the underhand. The plaintiff's solicitor then thought, oh, well, I'll see if I can bring a motion and get Hammerschlag to give us some leave to then have one more chance. The motion was granted. The plaintiff's solicitors failed to turn up at the motion. So it just kept getting worse. Eventually, the opponents decided to say, well, we're going to approach the court now and see if we can get these proceedings dismissed. This is crazy. How can we be expected to respond to a claim when the plaintiffs are in continual default? The court determined what to do. Do they dismiss the proceedings because of the default or do they deal with the defaults? And what Justice Stevenson decided was it wasn't actually the Berry Rural Co-op Society, so the client. It wasn't actually the client's fault that there were the defaults. It was actually the plaintiff's solicitors. And in fact, he said, and this is the bit that I quote because it is so harsh, the invidious position of the cooperative, which is the plaintiff here, is due entirely to the egregious shortcomings in the manner in which its legal representatives have conducted these proceedings. So I think there are sections of the judgment where Stephen says the manner in which the litigation was conducted was a disgrace. The court decided to allow the plaintiff time to put on evidence, but at the same time ordered that the solicitor on the record personally pay the costs thrown away of the motion and the delay. In addition to making that order, the judge also ordered that not only the solicitor with the carriage of the matter, but the partner on the record come before the court and explain themselves. And the explanations that were offered were considered very dimly by the judge. The judge essentially said, one was, I didn't put a diary entry in for the date, or I slept through my alarm. It was. The
dog ate my homework.
This is why I say it is just such it is sort of the worst scenario, but it clearly happens. And the other thing that I think a lot of lawyers will be aware of, the judge went further than ordering the cost be paid personally, and also ordered that his decision and the reasons for his decision be circulated to the plaintiff's solicitor's client. Every board member of that client read those reasons. So there would have been a massive personal reputation hit for this lawyer, in addition to the personal cost.
And the solicitor actually had to provide proof that he had distributed the decision to the board of the plaintiff.
That's right. So it's a very sobering reminder. I mean, the court processes now, the court, like we said before, we talked about technology trying to streamline the systems. You've got Section 56 of the Civil Procedure Act, which is all about the just, quick resolution of litigation. So judges now are taking those mandates very seriously. They are aware of the delay and cost of litigation, so they're not tolerating any truancies, if you like.
Oh, absolutely. And as to why this occurred, you can only guesstimate. I mean, we know he talked about sleeping through alarms. I think in this particular case, the principal was relying on his junior lawyer to perform the work, certainly to turn up to court. There obviously was insufficient supervision in respect of it. Whether the junior lawyer put his head in the sand and it just went from bad to worse,
too hard,
which
maybe.
is understandable.
Yes,
It may have been far too hard for him and he just didn't want to do it. Good risk management lesson is don't take on matters that you don't have experience in. Don't think to yourself, oh, this might be a good matter to take on. I don't really know the area, but I'll just brief counsel and those types of things.
That's right.
Ensure that you've got the resources within your firm to handle it. Do you have the people that can turn up at court? And
that's right, and systems even, diary entries.
Systems and things like that. And also the fact that if you are the solicitor on the record and things go wrong, there is a very real risk of obtaining a personal cost order. And the courts now are handing them out fairly freely, not unfairly, but freely if they feel. Then they're not, as you said in the beginning, they're not going to slot the actual client because the client is not to blame.
No, and often the
other
judge will
party.
see that. They'll identify where the real fault lays, and it's often the client doesn't even know in many cases that orders have been missed.
Which I think is why he specifically wanted to make sure that the client got the right story.
Yes, yeah, I agree, which I thought that was a very unusual but a very interesting judgment. So.
And talking about diary systems, I mean, that brings up another issue of limitation periods.
Yes, well, as law cover, you would have seen over the years many cases and claims that have arisen out of missed limitation periods.
And that's why law cover does put out a schedule of limitation periods on civil matters within New South Wales. And it's interesting, one solicitor said to me one day, he said, you know what I do? He said, I get a copy, when I get the latest copy of that, he said, I get extra copies. He said, I put one on every solicitor's desk so that when their clients come in, the first thing there in their eye is a limitation period, so that the first thing they say that they're thinking of is this a limitation issue?
Yes. And, that's good too.
Is there a
Yes.
limitation period in respect of it?
Front of mind.
If it's a personal injury matter, you've got to
Yes.
think of limitations. That should be front of mind.
I think that's
the
useful
first thing.
too when you do have, sometimes you have solicitors who are on leave or you have staff turnover, and if you do have something documented at the front of the file, then no matter who picks up that file, it's the first thing they think about, whether that's something that they need to be mindful of. I think that's great
Absolutely.
risk management.
Yes. And I often say that I should be able to, or anybody, because there are changes of staff all the time in solicitors' practices, and if people have documented file notes and put the court documents in order, you should actually be able to start at page 1 of the file, and by the time you get to the last page, you should know the history of the file, you should be able to understand it, you should know what needs to be done next,
Yes.
at what time, where, how,
And if there are any looming deadlines, that's right.
so the importance of having a really good organised filing system in respect of litigation, I think it is essential. And it's a matter for you. Some people have files with, they have court documents in one file, they'll have correspondence with the clients in another file,
Yes.
They'll have affidavits in another file, whatever way you like to organise it.
But I think it is about a system. It's
It
about
is.
having a
Yep.
consistent system, and litigation is fast-paced, and you need your system sorted out so that when you are beginning proceedings or defending proceedings, you've got the support you need to make sure that it's going to proceed in a way that you're not getting any personal cost orders against you.
Probably the next matter, which probably is applicable to most areas of law and not only in the litigation area, and something that comes up a lot is conflict of interest.
And the case that I think you're going to talk about is at Gordana.
That's
yes.
the one.
So Gordana, Smith and another, and Colin Steingold. That is, it's not necessarily what people think of immediately when they think of conflict of interest, but it's excellent in. I think it's something to be mindful of. Were you going to talk about the?
Yes, Gordana Smith matter. This is where the solicitor was acting for the first and second defendant in the shareholding proceedings. However, in the past, the solicitor had not only acted for these defendants, they'd also acted for the plaintiffs on both an individual, personal level and in respect of their positions in the company, at the company level. The solicitor ceased acting for the plaintiffs and the company and then decided he would only act for the defendant. The plaintiffs obviously then alleged that the solicitor was aware of confidential information and familiar with the conduct and character of the issues and in the context of the litigation due to their past association. And the solicitor was restrained from acting for the defendants. And Rain, Justice Rain, actually quoted here, said, even if Mr Russell will not be a witness, the point remains that he has acquired knowledge and experience of Mr and Mrs Smith as their solicitor, and further, the case is one involving allegations of a kind that bring Mr Russell close to the issues in the case and raise the real possibility that he will have information or knowledge of the plaintiffs that he would not have obtained if he had not acted for them in the past, and which could be relevant to his consideration of these particular issues.
Look, and I think that's a great quote, because it is true. Even though you say I'm acting for a different entity now, and it is difficult when you've got directors and companies and shareholders, which is again also working out who your client is. You definitely do get a sense of what your client's appetite for risk is, whether they're inclined to settle, whether they're going to be bullish, and knowing that information about a potential opponent is a real tactical advantage, and I think that's absolutely a conflict of interest, and the solicitor should never have accepted that retainer.
Yes, it talks about the familiarity with the party's strengths and vulnerabilities, not so much to actual information It's as who they are as people, and as you said, as to the risk appetite.
That's right. I find in my experience with litigation, 80% of it is actually driven by the various personalities that are involved in the litigation. So it's actually a very significant part of how you manage a case and whether you resolve or fight. So
Absolutely. And look, it's not necessarily a conflict there, but if you are familiar with these particular clients, you should consider your position before taking instructions of acting against former clients. Directors, employees, individuals, I would probably err on the side of caution.
That's right.
And say that I cannot.
Well, the other
act.
option is to seek informed consent. So if you think that you can salvage the relationship, you can seek consent from everybody if you explain the risks. But I think you're right. To err on caution would
There's
be the
actually
safest.
been an unlitigated matter at Law Cover where informed consent was given and the conflict was really still there.
Still real.
Notwithstanding the
Yes,
informed consent.
interesting.
So I just think err on the side of caution.
Don't go there.
Don't go there. Recommend, refer, but you're better off just playing the safe road.
Well, look, and if you've got a repeat client in that case where you do act for the company and the various directors, it's much, if you are worried about turning away work, it's certainly a better long-term solution to have a client that's happy for the long term rather than risk the relationship over one piece of litigation.
Absolutely. We were talking about systems before and courts being online and those types of things. Your claims prevention tips for that, what would you say? I mean, I think obviously you would need to have incredible systems in place, monitor your email traffic frequently.
Email's a big one. I think I mentioned earlier
Yes.
online court, that, you've got 24-hour turnaround for those. So say, for example, you've got one contact person in the firm and they're getting the online court emails and they're not responding. That's a real concern because the court does have the capacity to ask you to show cause if you haven't entered orders. So email traffic, definitely.
Email traffic, I think, has become a huge trap. And I think it's a common way that people communicate these days, especially in the legal field, and I think especially in litigation. You're going to be getting emails from your client, you're going to be getting emails from the other side, emails from the court. I remember in the early days of emails, people used to say you shouldn't monitor your emails, you just look at them at 9 o'clock in the morning and then do your work and look at them again at 3 o'clock in the afternoon.
If you did that now, you'd get 10 phone calls. Have you got my email? Why haven't you read my email?
Well, it's the expectation now that people want instant responses.
That's right. Yes.
And I think if in any matters at all, if you are not prepared to give those instant responses, you've got to say to your client things like, please send, this information by email. I won't be responding to it instantly. I won't be ringing you up in 10 minutes. I will deal with it and get back to you as the matter dictates. It may be 2 days.
Yes.
It may be a week.
So that is about managing expectations.
Absolutely.
So that is a theme here for the negligent management of litigation as well. So much of it is, and you know this, is
Absolutely.
communication and managing your clients' expectations. If they know that you're not going to respond unless it's going to be within 24 hours, they're not going to call you 10 times wondering if you've had the email. But if they're expecting you to be, available every 5 minutes, then you are going to hit roadblocks. So it is. I definitely think for me the risk management messages are communicate with your clients and manage the expectations, and particularly with litigation because it can be fraught.
Absolutely. And manage their expectations of the actual court process.
Yes.
That it is a long road to hope clients get very frustrated and can't see why it does take so long and the process. And I think communicating that to your client is, essential. And as you say, manage their expectations that things are not going to happen overnight, be it a response to an email or the court process.
Yeah, that's right. And we
itself.
forget too, as litigators, we're in court or responding to court orders or dealing with evidence every week. Our clients aren't. We need to explain what it means when there are court orders made and the significance of compliance and things like that. So, yeah, it is. It is all about communication.
It's an unfortunate thing that we could probably talk all day.
I could go on.
On and on and on about matters. But I think it is essential. I think what we've learnt today is it's management. It's time management. It's people management. It's supervision. Supervision, again, is becoming a big issue. It's great to have the trust of your employees, but principals have got to remember that, if they are employing people, that it is incumbent upon them to supervise.
That's right.
They are the solicitors on the record, and at the end of the day, the buck will stop with them.
Absolutely.
And that now courts are more inclined to award personal costs orders. When I started in litigation, there was no such thing as a personal costs order.
Yes.
But now it is becoming where solicitors are being held responsible for their actions or lack thereof.
Or lack thereof. And it's the courts trying to control their own processes. They really are using every tool that they have in their toolbox to make sure that the experience for litigants is as streamlined as
possible.
Fast as possible.
Absolutely.
That's right.
Well, thank you very much
My pleasure.
for joining me today. And I also want to add that Melissa very competently and kindly also conducts our face-to-face risk briefings, which are 2-hour risk briefings, delving into a lot more detail than what we have been able to today. I certainly recommend it to all solicitors, and particularly to employed solicitors. I think that sometimes they don't realise that they need to be responsible, as responsible for the risks involved as their principals are. So thank you very much, Melissa.
Thank you very much for having me, Janice. Great to speak to you.
Thanks for listening to Risk on Air by Law Cover. Join us for the next episode and subscribe to stay up to date.